I am grateful for the opportunity to talk to you briefly about the marriage cases at the Supreme Court. Those are Hollingsworth versus Perry, challenging California's Proposition 8, and United States versus Windsor, challenging the federal so-called Defense of Marriage Act, or DOMA, both as violating the constitutional guarantee of equal protection of the laws. These cases were argued the last week in March, and the court will almost certainly decide them by the end of this month. The Supreme Court could decide these marriage cases in a variety of ways. In the worst case, the court could uphold both laws, presumably holding that sexual orientation discrimination is constitutional so long as the government has a rational basis for it, which is a highly deferential standard that sometimes allows rather strained justifications to uphold a law. This would mean that same-sex couples could not marry again in California until Prop 8 gets repealed through a new ballot initiative, and that the federal government would not treat legally married same-sex couples equally until Congress manages to repeal DOMA. Alternatively, the court could hold that Prop 8 is constitutional, but that DOMA is unconstitutional, perhaps with one or more justices appealing to notions of federalism to argue that marriage regulation is the business of the states, not the federal government. In this scenario, we would still need an initiative to repeal Prop 8, but the federal government would promptly stop discriminating against married same-sex couples. The flip situation, with the court upholding DOMA but striking down Prop 8, seems least likely legally. That leaves then for the fourth scenario a double victory, with the court holding DOMA unconstitutional and either holding Prop 8 unconstitutional or dismissing the Prop 8 appeal, reinstating one of the victories in the lower courts, either on the ground that the ballot sponsors lack standing to be litigating this case, or because the justices simply decide not to address the merits of the marriage ban after all, instead dismissing the appeal in technical terms as improvidently granted. This double victory would ensure that the federal government treats married same-sex couples equally and that same-sex couples in California could resume marrying, although that could take some time for further briefing in the lower courts if the Supreme Court simply dismisses Perry. Although there are complicated jurisdictional questions in Windsor as well that could keep the court from addressing DOMA's constitutionality, that does not strike me as highly likely. DOMA is a federal law, and numerous lower court decisions have held it unconstitutional. Sooner or later, probably sooner, the court is going to have to decide whether the law does violate the guarantee of equality in our Constitution. Moreover, the preliminary briefing made the jurisdictional issues clear to the court, yet out of the various DOMA cases that were pending before it, the court only chose to grant review in Edie Windsor's case. So I think we're likely to see them pass on the merits of that case. On the other hand, the court might well punt in Perry. Swing conservative Justice Anthony Kennedy, echoed by liberal Justice Sonia Sotomayor, both suggested at the oral arguments that perhaps the court shouldn't be deciding the marriage issue yet. Their hesitation, coupled with Justice Ginsburg's public pronouncements about the importance of the court proceeding cautiously and incrementally in socially divisive constitutional cases, along with the conservative justices' contempt for the equality arguments in the case, might lead a majority of the court to vote not to decide the constitutional questions at all. Now, the fact that the legislatures of Rhode Island, Delaware, and Minnesota all passed marriage equality laws last month, absolutely. Those developments, after the Supreme Court heard arguments in the marriage cases, could be a two-edged sword. On the one hand, they could suggest to some justices that the direction of progress is towards inclusion in marriage, and thus support any inclinations that some justices may have to vote in favor of equality in the cases pending before it. But these new marriage equality states could also suggest to some justices that the political process is working and that courts need not treat sexual orientation discrimination as suspect or quasi-suspect, but instead should defer greatly to majoritarian lawmaking on the subject of marriage. We simply have no way of knowing how the court is going to rule in Perry and Windsor until it actually announces its decisions later this month. In the meantime, in this month of Pride, we should prepare to celebrate any victories we might obtain, including a dismissal in Perry, which, as I said, would not put Californians' right to marry on as secure a footing as a decision flatly saying that Prop 8 was unconstitutional, but which would let same-sex couples resume marrying here. At the same time, however, we should prepare as well for coordinated action if the court in the Perry case renders anything less than a clear holding that the odious Proposition 8 is unconstitutional. As a constitutional scholar, I know that public support is essential for the long-term enjoyment of rights, even constitutional rights, like the right to equality or the right to marry. Public opinion in California has shifted on marriage equality in a positive direction, in part due to educational efforts of groups such as Equality California. And we may need to capitalize on that if we don't win everything we should at the court. We'll know one way or another in just a few weeks. Until then, fingers crossed, everyone.